Good morning, everyone. On behalf of the Corporate Education Unit at CIPC, I would like to warmly welcome you to today's webinar. My name is Pearl Ndlovu, and I will be your facilitator for today's session. Thank you for taking the time to join us. We are delighted to have you with us for this informative webinar on company registration and introduction to intellectual property for small and medium enterprises. Whether you're looking to start a new business, formalize an existing one, or protect your business ideas and creation, today's session is designed to provide practical guidance on two important aspects of building and growing a successful business. During the webinar, we will begin with an overview of the company registration process, including the key steps involved in registering a company through the CIPC and the benefits of formalizing your business. We will then move on to an introduction to intellectual property, also known as IP, and explore why it is important to protect the valuable assets of your business. The session will cover the different types of IP, including trademark, patents, design, and copyright. Before we continue, a quick but important reminder. At CIPC, we keep it clean. No fraud, no corruption, and no shortcuts. Whether you are an employee, client, stakeholder, or service provider, honesty is non-negotiable, and any suspected fraud should be reported through the correct CIPC channels. A few housekeeping notes. This webinar is being recorded, and the recording, as well as the presentation slides, will be emailed to all registered participants after the session. Please feel free to post your questions in the chat throughout the presentation. We will address as many questions as possible during the Q&A session. At the end of the webinar, we will share a link to a short feedback survey in the chat. We would greatly appreciate your participation as your feedback helps us improve and continue delivering valuable educational sessions. I am pleased to introduce our presenters for today's webinar, Shani Kelly, an education specialist from the Corporate Education and Compliance Unit, who will be presenting on company registration. Mr. Mojalefa Koza, a senior education specialist from the Copyright IP Unit, who will be presenting on introduction to intellectual property. Our goal today is to equip you with a better understanding of how to register your business and how intellectual property can help protect and add value to your ideas, products, services, and brand. We encourage you to stay engaged, take notes, and make the most of this opportunity to learn from our CIPC specialist. With that said, let us begin. Shani, over to you.
Good day, everyone, and welcome to another amazing webinar with the CIPC. My presentation today is going to be on register the business, protect the value. A brief introduction. CIPC was brought into existence by the Companies Act of 2008 in terms of Section 185, subsection 1 of the Companies Act. The Commission is established as a juristic person. CIPC functions as an organ of the state within the public administration, but an institution outside the public service. The Commission is an independent regulatory body within the public administration. Now, CIPC is divided into two categories. We have the business registration and corporate regulation, as well as intellectual property. Under the business registration, we have companies, cooperatives, and closed corporations, commonly known as the CCs. Under intellectual properties, we have patents, designs, trademarks, and copyrights. Register for a genuine business purpose. Confirm that there is a real economic opportunity or clear business reason before you register your business. Understand the ongoing compliance, reporting, and administration obligations involved when you have a registered business. Decide on the appropriate company type and who will be the directors. Use each director's own accurate cell phone numbers and email address. What is a company? A company is recognized as a separate legal entity from its owners. It has the capacity to enter into contracts, own properties, and initiate or defend legal proceedings in its own name. It has limited liability. Shareholders are typically not personally liable for companies' debts beyond the amount that they have invested. It enjoys perpetual succession, which means it continues to exist despite ownership changes or in the death of a shareholder. Types of companies. Remember, choose the appropriate profit companies. We have two categories of companies. We have a profit company and a non-profit company. A profit company is established to conduct business and generate financial returns for its shareholders. A non-profit company is established for a public benefit or social purpose. Its incomes may not be distributed to its incorporators, members, or directors, except as reasonable compensation. Okay, the types of profit companies you get. You get a private company, which is a PTY Ltd, privately owned and may not offer its shares to the general public. Minimum one director. It costs 125 Rand or 175 Rand with name reservations included. A private company is an example of a private company is Woolworths Financial Services. It's a PTY Ltd. A public company may offer its shares to the public and can be listed on the stock exchange. That's the JSE, right? An example of a public company is Vodacom Group Limited. A state-owned company, that's a SOC Limited. It owns or controlled by the government and generally established to provide strategic services. For example, Eskom Holdings. A personal liability company is mainly used by professional practices. Current or past directors may be jointly liable for certain companies' debts incurring during the time it's in office or they were in office. An example, it's a law or an accounting practice. Types of non-profit companies. A non-profit company, that's an NPC, is established to promote social, cultural, educational, re- religious, or community objective rather than to generate profit for its members. An NPC must reserve a name, as the use of a registration number as its name is not allowed. An example of an NPC is the Gift of the Givers Foundation. Now, the company registration journey. Number 1, create or access your CIPC customer profile. Point 2, choose the company type and decide on a name option. Remember, an NPC must reserve a name. Capture the company, the director, and incorporator's information. Complete director verification and pay the prescribed fee. Point 4, receive the registration document and company number. This is the company registration number. The cost for registration. A private company registration without a name is 125 Rand. Remember, for a private company, the name is optional. But for an MPC, the name is not optional. It's compulsory that you have a name. For a company name reservation, it's a 50 Rand. And a private company registration, including the name, is 175 Rand. The fee depends on the selected registration and name option. Name reservation is optional for private companies but advisable when a specific name matters. Submit 1 to 4 proposed names in order of preference. The fee is still 50 Rand and it's payable for each name reservation application. So you can, on one application, you can use 4 name options. A private company may register using its registration number as its name. When reserving a name, it's advisable to do a trademark search, enterprise search, and a browser search. This is to identify possible other businesses that already have rights or uses the name or similar name to what you are considering. After registering your business, you can also trademark your name. A company name is not the same as a trademark. A company name identifies the registered legal entity on the company's register. A trademark distinguishes goods or services in the market. Registering a company name does not automatically protect its logo or brand. Formalize the business, then identify and protect the IP that creates value. CIPC's contact channels. We have our call center at 086 100 2472. We have walk-in centers and self-service centers throughout South Africa. Their addresses are available on the CIPC website. We have an online inquiry system called SEMS. That's the Customer Inquiry Management System. The CIPC website, which has an abundance of information for new SMMEs, as well as existing ones. We have the BIS portal platform, as well as our social media channels. We have Facebook, Instagram, Threads, LinkedIn, YouTube, and X. So there are a variety of channels. Please follow one of our channels on social media. Registration is the beginning, not the finish line. Now protect what makes the business different. Thank you very much.
Thank you so much, Shani, for that informative presentation. I will be moving on to Mr. Koza, and he will be presenting about intellectual property. Over to you, sir.
I see the gremlins are taking a bit of time on our screen at the moment. Please remember to post all your questions on our chat, and we will attend to it as soon as Mr. Mojalefa has completed his presentation. Thank you, there's it. Mojalefa, you can unmute your mic and start. Mojalefa, I think your mic is still on mute. Please unmute it.
Good morning, everybody. Can you hear me now,
Yes,
Shanae?
loud and clear.
And then
Yes.
is my presentation visible to everybody?
Yes.
Yes.
Just put it on presentation mode. Thank you.
All right. Thank you very much. We had a little technical glitch, but it's sorted now. Thank you, Pearl, for the warm introduction. Again, my name is Mojalefa Koza. I am with CIPC. I'm in a division called Innovation and Creativity, and I am in a unit called Copyright. I'm a senior education specialist there, and my responsibility is to put together all outreach programs on intellectual property. And today, as an SMME, I would like to use my presentation to help you identify intellectual property in your business and in your day-to-day running of your business. So let's get right to the presentation. One, I'm not going to spend a lot of time introducing my establishment. Shanae has already done that, but I'm going to talk about the legislative framework. In other words, I'm going to talk about the legislation that we administer as an establishment of government only as far as intellectual property is concerned. Then we're going to go to the topic of the day. I am going to use South African stories, intellectual stories that I have come across to try and define the concept of intellectual property. Then I would move straight into the types of intellectual property so that as an SMME, you begin to be able to identify the difference between all these different types of intellectual property and begin to appreciate the relationship between them. And finally, if time allows, I will talk a little bit about careers that you can consider as an SMME. You probably somewhere along the way would like to change your business direction, and these are the options available to you. Yes, Shanae has said that CIPC was brought into existence by the Companies Act 78 of 2008. When it was amended, it gave birth to an institution that you and I call CIPC, short for Companies and Intellectual Property Commission. Now, if you look at the acronym of our establishment, the first C stands for companies, the IP in the middle stands for intellectual property, and the final C stands for commission. So we are a commission that takes care of companies and intellectual property. intellectual property rights. This is our function. I am not going to go through all the functions, as Shani has already spoke about some of them, but please note that we continue to register companies that Shani has spoken about, including cooperatives. And on the other side, we register what we call intellectual property rights. And that is the subject of my discussion with you today. We disclose information on our register. We do enforcement of all relevant legislations. That means company legislations as well as intellectual property legislations. Then in terms of Section 182 of the Companies Act, our mandate is also to promote education and awareness. In other words, our responsibility is to talk to all South Africans, not only about company laws, but about intellectual property laws. Then we do licensing of business rescue practitioners. What we do here is, if you want to be a business rescue practitioner, you apply with CIPC. If you meet the requirements, we give you a license to be a business rescue practitioner. If you ask, what are business rescue practitioners? Business rescue practitioners are all those professionals who've got the experience, who've got the qualifications, who've got the repertoire of turning around the fortunes of a company that is not doing well. We also monitor compliance. We do research and advice. And upon research and advice, we advise the minister, which is the Minister of the Department of Trade and Industry and Competition. Finally, when the Companies Act was amended, our mandate was also increased. We do accreditation and regulation of collecting societies in music only so far. In other words, we do not accredit and we do not regulate collecting societies in books, in films, in all other types of copyright. Our focus as far as the accreditation and regulation is concerned is only in music. Now, what are collecting societies, if you may ask? One, collecting societies are non-profit organization. They should be non-profit organization. And what do? One, they represent performers in music. They represent record companies in music. And what do they do for them? One, they monitor the usage of their music. In other words, they look at all the people or all the organizations that play the music of their members. Such organizations include 1, radio stations, 2, retail stores, 3, airlines, restaurants, and pubs. In other words, these are the users of the music. Now, every time a radio station plays a song, they should pay for the playing of the song. It's called needle time. So this is what collecting societies do. And every time a retail store plays music, it should pay what we call royalties to the owner of the music. So collecting societies monitor the usage of the music. Number one, they dish out licenses to all the users of the music. In other words, they give them permission to play the music of Tyler or the music of Cassper Nyovest, for example, and they negotiate tariffs. In other words, how much should they pay every time they play Tyler's song? And after that, they do what we call, they collect all the royalties over a certain period of time, usually between 6 months and a year. And upon collection of those royalties, they distribute the royalties to their members. And their members are performers in music. Their members are recording companies. But before they distribute the royalties, in terms of our regulations, they have to submit what we call a distribution plan to CIPC. We look at the distribution plan. We scrutinize it. We look at the data and the money paid to see if there is a correlation. In other words, we look at the data. How many times has Cassper Nyovest songs been played in radio stations, in retail stores? And does it correlate with the amount that is paid to Cassper Nyovest? So in a nutshell, those are the functions of CIPC over above registration of companies. These are the legislations that we administer on behalf of the Department of Trade and Industry and Cooperation, which is our mother department. But I'm going to talk about legislations that pertains to intellectual property only. One such legislation is the Copyright Act. Now, this is the legislation that protects your literary, your artistic, and your creative works. What am I talking about when I talk about literary, artistic, and creative works? Examples are music. Examples are paintings, photographs, books. All those are called literary, creative, and artistic works. And those works are protected by the Copyright Act. Then, related to the Copyright Act, we have what we call the Performance Protection Act. And what does this legislation protect? It protects performance in music. It protects performance in films. And what is performance according to the Performance Protection Act? Performance relate in music, for example, that lady who sings in a particular song, that singing is regarded as a performance in terms of the Performance Protection Act. And it's a right, and it's a right that is protected, and it belongs to the person who sings. As far as films are concerned, what can be termed performance in films? That acting that takes place in a film, it's called performance in terms of the Performance Protection Act. And that act of performing is a right, and it belongs to the performers, meaning the actors. Then we've got the Patents Act. Now, this is the legislation that protects your innovation. This is the legislation that protects your inventions. We use those terminology interchangeably because they've got a very close relationship. Whether those inventions, whether those innovations are technical or non-technical in nature, whether they are technological or non-technological in nature, it does not matter as long as they meet the requirements of a patent. Then we've got the Designs Act. Many people still do not know that designs are regarded as a product of intellectual effort and are therefore protected. Those designs are rights, and those designs need to be protected. What type of designs am I talking about? I'm talking about designs of everything, from clothes, which is fashion, to furniture, motor vehicles. All those designs are protected by the owners of those designs, but they can only be protected provided they are new. In other words, do not come to CIPC with a design that you have copied from somebody else, because it will be declined on the basis that it's not new. Somebody already has that kind of design and has lodged for protection with CIPC. Then finally, we've got the Trademarks Act. Like Shani has said, the name of the company identifies the company. However, a trademark identifies the goods and services of a company. So with a trademark, we will protect the name of your company. With a trademark, we will protect the logo of your company. With a trademark, we will protect the slogan of your company. So we will also protect the names of the products of your company. So this is the purpose of a trademark. And below colored in red are international agreements where South Africa is a member. One such agreement is the Berne Convention of 1886. It is an international agreement where all countries who are members of the Berne Convention, like South Africa, agreed to protect copyrighted works all over the world in the countries who are members of the Berne Convention. So what does it mean? It means since South Africa is a member of the Berne Convention, we are duty bound by virtue of our membership to protect copyright works from America, to protect copyrights of Europe in our country, and they are also duty bound to protect copyrights from South Africa in their countries. Copyrights such as music, such as films, such as patents. Then we've got the TRIPS agreement, which was signed in 1994, where all parties who are members of the TRIPS agreement agreed to trade equitably in terms of intellectual property products. Then we've got the Paris Convention, and this is an international agreement that relates to trademarks, where a single trademark registration system was designed for all countries who are members of the Paris Convention. Then finally, we've got the Patent Corporation Treaty. The name is self-explanatory. The Patent Corporation Treaty is a single international application system for patents. In other words, if you want to apply for patents all over the world, you take advantage of this system because it's an international registration system for patents. What you do here is when you apply, they will conduct what we call a world patent search. And when the search report comes, it will tell you countries where you can be able to apply for a patent because nobody has applied for a patent before in those countries. So in a nutshell, those are the legislations and those are the international agreements where South Africa it's part of. Now let us go to the topic of the day and try to understand what intellectual property is. Where there is an internationally agreed definition of intellectual property, it simply means the creation of the mind. But what exactly do we mean by the creations of the mind? I'll give you an example. If Mojalefa uses his mind and at the end of the day creates something or come up with something that is new, something that nobody has ever done, then that refers to the creation of the mind. And what do we call that creation of the mind? We call that creation of the mind intellectual property. Let us break it down a little bit more. If you look at the word intellectual, it comes from the word intellect, which simply means the mind. And property simply means something that belongs to somebody else. So if Mojalefa creates something new, uses his mind, then that becomes Mojalefa causes intellectual property. That means Mojalefa is allowed in terms of the intellectual property regime to explore financially his intellectual property. Anybody else who does not own this intellectual property is not allowed to exploit it or to explore it financially. Such intellectual property might result into an invention or an innovation. I will explain in the coming slides. Or such intellectual property can become literary or artistic works, such as music, such as paintings. Such intellectual property might be a design of a chair, might be a design of furniture, it might be a design of a car, it might be a design of clothes or fashion, or if you like. Or finally, that intellectual property might be a symbol, such as a logo. It might be a name of a company. It might be a name of a product. So depending on what type of intellectual property it is, you should be aware. If you think that you have intellectual property, you should be aware what type of intellectual property is in your hands. Is it in an invention that would be protected by a patent? Is it literary or artistic works that might be protected by copyright? Is it a symbol, a logo that might be protected by a trademark? Or is it a design of a fashion apparel that might be protected by design? And then if you look at the bottom of my screen, we have what we call an idea. Intellectual property always starts with an idea. And sometimes intellectual property solves a particular challenge. I will explain that in the later slides. It always starts with an idea. Now, as an SMME, when you have an idea, what do you do with that idea? Do you sit on the idea or do you work on the idea? Do you think outside the box? Now, if you have an idea, the most logical thing to do is to work on it, innovate it, think outside the box. And when you have done that, that idea would finally culminate into a product which we call intellectual product. intellectual property, and that idea should be protected by you, the owner of the intellectual property. Otherwise, if you do not protect that idea, somebody might take the idea, run with the idea, and become an overnight millionaire, while you, the originator of idea, gets nothing. That is the definition of intellectual property in a nutshell. Now, here's a beautiful intellectual property story that I came across as an information officer on intellectual property. 9-10 years ago, I met a young man called Lufeve Nomjana, pictured here in this slide. This young man, I met him in a township called Langa in Cape Town, and I was talking to the community about intellectual property. This young man was a student then at the University of Cape Town, and he was studying business studies. And after my presentation of intellectual property, he approached me and we started having a conversation. And he said to me, Mr. Khoza, I have listened to your talk on intellectual property. And after your talk, I think I have intellectual property. And my question to him was, okay, Lufeve, you say that you have intellectual property. What do you have? He said to me, I have come up with a bread, B-R-E-A-D, and I think this bread is intellectual property. And my response to him was, okay, Lufeve, are you aware that intellectual property is about coming up with something that is new, something that nobody has made before? He said, yes, I am aware. And I said to him, you say you have made bread. And as far as I know, bread is not something new. Bread has always been there in the market. I have known of breads like your Albany, like your Blue Ribbon. And he said to me, this is what is different about my bread from all those bread that you have mentioned, Mr. Khoza. And that caught my attention. And I said, okay, Lufeve, how different is your bread from these breads that I know? Number one, he said, my bread is gluten-free. And I'm sure we all know that the bread that we consume has an ingredient called gluten. And we are told by health experts that gluten is not very good for our health. And once he said that his bread does not have gluten, I knew that this discussion is going somewhere. And I said to him, what else makes your bread different from all these other breads? Then he said to me, the bread that I have made has spinach as one of its main ingredients. Number three, he said, one of the ingredients in my bread is green pepper. And once he said that, coming from the IP office, I knew that this young man has got intellectual property, because ever since I was born, I have never seen bread made out of spinach as an ingredient. I have never seen bread made out of green pepper as an ingredient. According to me personally, this was a groundbreaking innovation within the bread space. And fast forward, I agreed with him and I said, Lufeve, you have intellectual property. I agree with you. Then I had some word of advice from him. I said, Lufeve, now you need to protect your innovation or your invention. And I gave him a couple of options. One, I said, you need to apply for a patent at CIPC and protect the recipe of your bread. That's the first option that you have. Secondly, I said to him, you need to give your bread a name, just like all these other breads like Blue Ribbon and Sasco, and protect the name of your bread, which is your product, as a trademark. So fast forward, I asked him another question, and I knew why I was asking this question. And I said to him, Lufeve, now that you've got intellectual property, have you spoken to anybody about your intellectual property? And what he said got me very worried. He said, yes, Mr. Khoza, I've spoken to a company called Pioneer Foods, and I'm made to understand Pioneer Foods is a company that produces the bread Blue Ribbon. And I became specific and I said, what did you tell them about your bread? Said, no, I just told them that I've made bread out of spinach. I've made bread that is made out of green pepper. And I became more specific. And I said, Luveve, did you disclose your recipe to that company? And he said, no. And I was happy because the recipe is the intellectual property. The recipe is what you hide from the rest of your world. The recipe is your millions. And I was happy. And I said, Luveve, once you've registered your bread as a patent and a trademark, you can go back to Pioneer Foods because this time around, you'll be talking from a position of safety because that would be proof that you are the patent owner of the bread and you are the trademark owner of the name of your bread. So this is one of many intellectual property stories that I have come across, but I personally like using this one to explain to you what we're talking about when we talk about intellectual property. Here's another slide that explains intellectual property and the different types of intellectual property. If you look at the top left, I have deliberately used a cell phone to illustrate what we mean by intellectual property. One, if you look at the cell phone, I have used the patent to illustrate that there is a patent in a cell phone. Question, what is the patent in the cell phone? Yes, the patent in the cell phone is the technology that is used in the cell phone for you and I to communicate wirelessly wherever, whenever. But if you ask again, is there a design in a cell phone? And the answer is yes. If you look at all the cell phones, the designs look the same, but they are not the same. Those designs are protected by the companies who own the cell phones worldwide. And if you look again at the cell phone and ask, is there a trademark? The answer again is yes, there is a trademark. A trademark simply means a protected name. Nokia is a trademark. Samsung is a trademark. iPhone is a trademark. It means those names are protected worldwide by the companies who own these names. And if you by chance come up with your own cell phone, you cannot call it Nokia. You've got to give it your own name and protect that name so that nobody uses it. Finally, if you look at the cell phone and ask, is there copyright in the cell phone? The answer again is yes. Question, what is the most common type of copyright that you find in a cell phone? If you buy a cell phone in a box, you'll get what we call a manual of instruction. A manual of instruction is written down and it's copyright. And that right is called literary work. We'll talk about it when we discuss copyright in detail. So what is this slide teaching us? This slide is teaching us that there are 4 types of intellectual property. You can find 1, or you can find 2, or you can find 3, or even 4 in one intellectual property. In the case of Luveve's bread, he cannot apply for a design, it doesn't apply there. He cannot apply for copyright, it doesn't apply there. But he can only take advantage of 2 of the 4 types of intellectual property, namely a patent and a trademark. What is a trademark? Let us talk about a trademark in more details. Shani has said it in her presentation. A trademark, unlike a company name, is there to identify your goods and services as an SMME to the goods and services of your competitors. A trademark is there to make you stand out and say, this is who I am. I can give you better goods or I can give you better services than my competitors. For example, let us just talk about the banking sector in South Africa. We've got 5 major retail banks in the country: your Nedbank, your FNB, your Absa, your Capitec. Now, what do these companies have in common? 1, they are competitors. They provide the same kind of goods and services to you and I. They are financial service provider. They take care of our monies. But how do we identify between these 5 competitors. One, we identify them by their names, which is their trademarks. We identify them by their slogans. We identify them by their logo. When you see the color blue, what comes to your mind? You think Standard Bank. When you see red with a little white in the middle, you already think Absa. So what convinces us to choose between these financial service providers? Obviously, it is the quality of the service that we get from them. So a trademark is there to help you build your own unique brand and to protect that brand so that nobody can take advantage of the brand that you have spent resources to grow, to make money out of it. Now, when you have a trademark, which is the name of your company, when you have a trademark, which is a slogan of your company, when you have a trademark, which is a logo of your company, how do you protect it? One, you come to CIPC. You can do it online. You don't have to take a journey down to Pretoria. You can do it online. But we always advise, as Shani has said, that before you lodge an application for a trademark, do what we call a trademark search. This will tell you whether somebody has applied for a similar trademark before you. Because if somebody has applied for a similar trademark before you, we will decline on the basis that somebody has applied for such before you. So what does it say to us? It says when you have IP, the first thing that you have to do is to apply and protect it. Intellectual property protection works on a first come, first served basis, because once you have the idea, you might not be the only one who has the idea, but it is the one who approaches CIPC first and lodge an application for intellectual property protection who gets the protection. So if you have IP, make sure that you move as fast as you can to protect it before somebody else does. So that is a trademark. Now, here's a beautiful South African trademark story that I like to talk about to emphasize the importance of you as an SMME coming to CIPC and applying for a trademark and therefore protecting your trademark. We all know Bafana Bafana by now, that when we talk about Bafana Bafana, we're talking about our national soccer team. But where does the name come from? I don't know. But we can assume that the name comes from South Africans. Who came up with the name? We don't know. But what we can tell you is that before 1994, because of the apartheid regime, we were not allowed to participate in international sport. Cricket, soccer, you name them. But after 1994, everything else changed. Then came the name Bafana Bafana. We started calling our national soccer team Bafana Bafana, which means the boys. And the name started growing from one province to another. And the name started growing beyond the borders of South Africa into Botswana, into Nigeria, into the Americas, and into Europe. But here's the catch. The South African Football Association made a mistake of their lives. And what was the mistake? The mistake was they never came to CIPC, apply for a trademark, and therefore protected. And this mistake did not go unnoticed. Somebody noticed the mistake and is a South African by the name of Wayne Smith, who, by the way, is the owner of the company called Stanton Woodbridge. Upon realizing this mistake in 1993, he came to CIPC. I was not working for CIPC then, I was working for Standard Bank. He came to CIPC, did a trademark search. And what did the trademark search report say? It said the name Bafana Bafana, it's not registered as a trademark, therefore legally it's up for grabs. He applied for a trademark and was granted a trademark in 1993 because there was no objection. Legally, what does it mean? Legally, what it means is Mr. Wayne Smith and not SAFA is the owner of the trademark Bafana Bafana. The story did not end there. Obviously, he got a registration certificate, waited for the right moment. And you know, in life, the right moment always comes. And in this case, it came in 2010. Remember, when South Africa won the right to host the World Cup, Soccer World Cup, the most prestigious soccer tournament in the world. We hear in the media that he obviously approached SAFA and stopped them from using the name Bafana Bafana because he is now the trademark owner. Well, according to media reports, we hear that SAFA did not have a choice but to negotiate. And when they negotiated, he licensed them. In other words, he gave them permission to use the name Bafana Bafana as a trademark only for the duration of the World Cup, which is a month. And we are told, we're not shown, that he charged them 3.8 million just for the usage of this trademark for a period of the month. So what does it teach us? It teaches us that when you have what you think is a trademark, come to CIPC, apply for protection, then you become the legal owner of the trademark. It simply means if it's not protected, it's up for grabs. If you do not apply for protection, somebody can take it, run with it, and become the legal owner of that. The story did not end there. The World Cup came, the World Cup went. After the World Cup, SAFA had two choices. One was either to stop using the name Bafana Bafana or to negotiate with the owner, who is Wayne Smith, to buy it. Finally, they decided to negotiate with him to buy it, and we are told, according to media reports, that he finally sold the trademark Bafana Bafana to them for another 5 million rand. And how much did he spend to apply for a trademark? One, he only spent 190 rands for a trademark search. Two, he only spent 590 to register the trademark. So he has spent less than $1,000, and look at how much money he has made due to the mistake that was committed by our very own national soccer team. Now that shows you that you are a young SMME today. You've got the company name, but come to CIPC, apply for a trademark, and protect the name of your company, because you will never know what will happen in the next coming 10 or 20 years. Now, let us go to the second type of intellectual property, a patent. What is a patent and what does it protect? In fact, all four types of intellectual property gives the owner an exclusive right. A trademark gives the owner an exclusive right. The same happens with a patent. If you've got an invention, and that invention is a product or it's a process, you apply for a patent, you've got an exclusive right. And that exclusive right is granted to you by the Patents Act of South Africa. And that invention or that innovation might be a product. For example, Luveve's invention, it's a product which is a bread, and he obviously has to apply for a patent in order to protect the recipe of his bread. Once you are granted, protection will be granted to you for a period of 20 years. After 20 years, it goes into the public domain. And when it goes into the public domain, whoever uses your patent is not legally wrong, because your protection has expired. Here is an example of a beautiful patent that we granted the CIPC. Here is a young white lady who came up with this candle holder. I'm sure many of you are seeing this candle holder for the first time, because we know about the old candle holder that is designed like a saucer and that is so easy to fall. Remember, in the beginning of my presentation, I said intellectual property always comes with an idea, and sometimes intellectual property is there to solve a particular challenge. What is the reason why this lady decided to come up with this candle holder? Around 2017, 2018, in George or Neisner, there was an informal settlement. It was in winter. Somebody forgot a candle light, and his shack caught fire, and about 1,000 shacks caught fire. It was a very big tragedy. And what was the cause? The cause was somebody forgot to switch off the candle, which was in a candle holder. And if you know that candle holder, it's easy to fall. It fell, it caught fire, and it caused a tragedy. It is for this challenge and for this reason that this lady decided, I am going to come up with a new candle holder that has 3 legs, that is very strong, that does not fall easy, and that has a tight opening in the middle that can hold the candle very, very, very tight. So it started as an idea because of the challenge that is faced by many, many informal sectors. And because this was new, and because this was revolutionary, as CIPC, we granted this lady a patent. And by the way, she's a South African. And we want to call her and advise her to apply for a design, because I can see a design there. And we want to call her and advise her to give this candle holder a name and apply for a trademark. In other words, take advantage of the 3 out of the 4 types of intellectual property that we protect. So that is an example of a patent. And for CIPC to grant you a patent, there are 3 requirements that you need to meet. 1, your invention must be new. There must be novelty there. It means it must not have been made public. It must be new. Number 2, we want you to disclose the inventive steps to us as CIPC from A to Z. Number 3, we look at whether the invention has commercial value or not. If it has commercial value, then we are in a position to grant you a patent. And if you look at that candle holder and you look at Luveve's bread, are they commercially viable? In other words, does the market want it? The answer is yes. Therefore, we granted a patent. Now, if you look into this slide, the most important word here is the word territorial, colored in red. In fact, all 4 types of intellectual property are territorial, especially patents. What does territorial mean? It simply means when you apply for a patent in South Africa, your protection is in South Africa only. If you want protection in Botswana, in Namibia, in Nigeria, in the US, it means you also have to apply for protection there, provided nobody has applied for the same patent before. So if you apply for a patent, bear in mind that your protection is territorial. In other words, it is only in South Africa. Okay? How do you register a patent? You visit us on www.cipc.co.za, and like Shanae has said, you create a profile. Or if you already have a profile, you use that profile. We advise you to start by doing a patent search to check if somebody has not applied for that kind of patent that you want to apply for. 1, you can apply for a provisional patent, which will cost you only 60 rands. After the provisional patent, within a period of 12 months, the patent law requires you that you now apply for what we call a complete patent. But according to our patent law, you can only apply for a complete patent through the services of an IP attorney. In other words, for a provisional patent, you can do it yourself. You do not need the services of an IP lawyer. But for a complete patent, which comes after 12 months, which you must do it through the services of a patent attorney. And in South Africa, there are a number of patent attorneys that IP firms that you can approach, like your Spoor and Fisher, like your Adams and Adams. Why consider patenting? Is it always imperative for you to go the patent route, or do you have other alternatives when you think you've got a patent? But let us talk about the pros first before we can talk about the cons of patenting. The pros are that when you are an SMME and you've got a patent that your competitors do not have, that gives you a strong market position, that gives you a competitive edge, because you've got what your competitors do not have. Obviously, it will ensure that you get higher profit margins or return on investment. It will bring additional income into your company because you can license your patent to your competitors, or you can license it to other competitors outside the borders of South Africa. Let us talk about the Please Call Me cell phone applications, for example. When Vodacom got hold of the Please Call Me cell phone application, you all know the story. They licensed it to other mobile operators in South Africa, in Africa, and they made money out of that licensing. So that's how you can make money out of your patent. And when you have a patent, it gives you access to technology through cross-licensing, for example. It gives you access to new markets. Please Call Me, for example, was a product that was born in South Africa, but it found new markets in Africa. It found new markets in South America, where it is very, very relevant. And when you have a patent, you reduce the risk of infringement. In other words, if somebody wants to copy it and use it and make money out of it, the chances of them doing that are very, very slim. And of course, it also gives your company a very positive image. It gives your company a very positive image. Like I said, when I started speaking about patents, is it always the right thing to patent or not to patent? Sometimes it's a good idea to patent. Sometimes it's not a good idea to patent. Before you can patent, you must get advice, because it is not always a good idea to patent. And I'll show you in the coming slide. But before you patent, consider this. Is there a market for your patent or your invention or your product? Are there potential licenses? Can you license it to other companies? How likely are the others, especially competitors, to invent the same? Look at those before you make a decision whether to patent or not to patent. Here is a beautiful example that will give us light as to whether you can patent or you cannot patent. Coca-Cola is such one example. The guy who made Coca-Cola in 1886 made sure that nobody gets hold of the recipe for Coca-Cola until today. Now, it was for Coca-Cola, or the owners of Coca-Cola, to make a decision whether to go for a patent or a trade secret. But what we know, they decided they are not going to go for a patent. Instead, they are going to go for a trade secret. Now, what is the difference between the two? When you patent, you have to apply. You have to pay the fees. You get a registration certificate that you're the patent owner. In other words, in the case of Coke, you own the recipe. But why did Coca-Cola go for a trade secret or not a patent? I don't know. But I can only assume that they got an advice from their IP attorneys, and they advised them to go the trade secret route. When you go the trade secret route, it simply means that you do not register, but you keep the recipe, or you keep the potential patent a secret for as long as you are alive. If you Google the Coca-Cola story, we are told that the recipe for Coca-Cola is kept as a secret in a vault somewhere in Georgia, Atlanta, and only 12 members of the family have access to that recipe. Yes, with a trade secret, you don't have to register. The protection has no time limit. I think one of the reasons why Coca-Cola chose the trade secret route is because a patent is only protected for 20 years, after which it goes into the public domain. Somebody can copy the recipe. I think that's one of the reasons they decided not to go the patent route. So if you think you have a patent, ask yourself a question. Is it correct, or is it all right for me to patent or to go for a trade secret? To get that advice, consult an IP lawyer, because those are experts. They can be able to give you a very good a very good advice. Another advantage of a trade secret is that once you've discovered it, or once you've completed your recipe, like Coca-Cola, for example, it starts immediately. You do not even need to disclose. Remember, one of the requirements for CIPC to grant a patent is to disclose the invention or to disclose the innovation. Then once you have a patent, how do you commercialize it? How do you make money out of it? There are a number of commercial options available to you. One, you can sell it. When you sell it, it means you don't own the patent rights anymore. The buyer owns it and can do anything they want about it. But before you sell again, you need to get advice from a patent lawyer whether you can sell or whether you can license. If selling is the best option, obviously, the IP lawyer would do a thorough valuation of your patent, because if they do not do that, chances are you might undervalue your patent and you might undersell it, and that's something you might regret for the rest of your life. Another option is licensing. Licensing, it's much, much better. Depending on the kind of patent that you have, in that you still remain the owner of the patent. And what's beautiful about licensing is you can cross-licensing it. You can license it to a number of your competitors. And by licensing it, you will get royalties from the licensing. In other words, you can grant them permission to use it while you still remain the owner. Okay, another option is you can establish a joint venture. If we go back to Luveve's example, Luveve can go back to Pioneer Foods and say, I can sell you my recipe for 50 million rands, for example, or I can license it to you. For every bread that you sell, you can give me so much money, 2 rands or 3 rands, or they can go into a joint venture together and decide on the profit margins, whether they split 50-50, 60-40, 70-30. That depends on the kind of agreement they come into. And before you license, there are a number of licenses that are available to you. To know this, get a licensing expert so that he can be able to advise what type of license is particularly beneficial for you, whether to go for an exclusive license, a sole license, or a non-exclusive license. I particularly like a non-exclusive license because it allows you to be flexible. It allows you to license to more than one licensee, unlike an exclusive license which many big companies would prefer because it gives them leverage to do whatever they want with your patent. Okay, and then let us talk a little bit about designs. I said designs are also protected. And what do we protect in any design? We protect the shape of the design, like earrings. We protect the form, the pattern, or the ornamentation or configuration. All those things, they mean one and the same thing. We protect the shape of a product or an article. In this case, earrings are protected for the looks, or a screwdriver is protected for the function. But sometimes a design is there for the look, and sometimes it's there for the function, and sometimes it's there for both. Okay, sometimes it's there for both. Here is another design that we granted in 2018, and these designs come from a young South African from the province of Gauteng. His name is Zongeza Mandaba, and these are his beautiful designs. We granted because these designs are not copied from anybody else. There is a difference. If you look at his toaster, it's got the Ndebele decorations, and he uses wood for the legs of his designs. It was granted because it met the requirements for design protection in terms of the Designs Act as administered by CIPC. And we also want to call him and advise him to apply for a trademark, because you can see he called his products Ziyanda. So we've given out so many designs, but I particularly liked this one. Okay. Designs, how do you register them? Just like patents, you go to our website, create a profile. If you have a profile, an existing profile, use it. You go to IP registration and you register for your design, whether you register an aesthetic design, which is there for the look, or a functional design, or both. Okay, then finally, we are going to talk about copyright. Copyright is a little bit tricky. Copyright is a little bit complicated, unlike a patent, a trademark, and a design. Because when you apply for a trademark, a patent, and a design, you get a registration certificate that shows that you own that right. But with copyright, what makes it much more complicated is because in one copyrighted work, you might get 1, 2, 3, 4, or even 4 types of rights. Sometimes those rights may be owned by one person. Sometimes those rights may be owned by 2 or 3 more persons. That's what makes it complicated. That is why in copyright, we're not talking about one right. We usually talk about a bundle of exclusive legal rights. And I'm going to use music to explain what I mean by a bundle of exclusive legal rights. Let's use music as an example. If Mojalefa Khoza takes a pen and paper and write a song, that song that Mojalefa has write, the lyrics, it's a right called literary works, and that right belongs to Mojalefa because Mojalefa wrote the lyrics of the song. And if Mojalefa approaches Pearl to create the music, to compose the music or the melody, that melody is a right on its own, and it's called musical works, and the owner of that right is Pearl because Pearl has composed the melody or the music. And if we approach Umpile, because Umpile is a gifted singer to sing, that singing is regarded as a performance in terms of the Performance Protection Act, and it's a right, and that right belongs to Umpile because Umpile is the one who sings. Then the value chain goes on. We now approach a record company because we do not have money or the equipment to record. The record company will take my lyrics, they will take Pearl's melodies or music or notes or beats, and they will take the performance or the singing by Umpilwe and put everything together. In terms of the Copyright Acts of South Africa, what does the copyright, what does the record company own? They own a right called fixation rights or mechanical rights. So already it shows you that there are 4 types of rights owned by 4 different people. That is why in copyright we talk about a bundle of exclusive legal rights. So when the music starts selling, it means Mojalefa has to get a little for his lyrics, Pearl has to get something for her melodies or the beats or the rights, Umpile has to get something for her performance, which is the singing, and the record company has to get something because they've spent resources in putting everything together. So that's what it means by a bundle of exclusive legal rights. And in the same fate, when we look at films, you'll get a bundle of exclusive legal rights in films. Somebody might write a script for a movie, and that script is called literary rights, and the owner of that right is somebody who wrote the lyrics. The value chain goes on. Then comes into the picture the producer who's got the money to produce the movie. Obviously, he would own the movie, but not what is included in the movie. And then comes the actors themselves who act. That acting is called performance. It's a right and it's owned by the actors themselves. And if the producer wants to use music, maybe a song, remember that song is owned by Mojalefa, by Pearl, by Umpile and Kalawa Jazz Music, for example. In other words, he has to get permission from us because we are the core joint owners of that song, and he has to get permission from us. We negotiate whether we sell the song to him to use as a soundtrack, or whether we license. And we are going to talk about how much. Here is a story that I like using to explain the importance of copyright protection. And this is a story about a young man from Gauteng, from a township called Tembisa. He is a gifted painter. He paints photographs, he paints pictures for a living. You can check him out. He always places his paintings on Instagram and other social media. So what happens is Nando's, one of the biggest fast food outlets in our country, they see those beautiful paintings and they take those paintings and they use those paintings in their advertisement. And this came to the attention of this young man. What I like about this young man is, like, unlike many South Africans who do not know that they own the intellectual property, he knew that he was the copyright owner of the paintings. He saw that advert and he saw that Nando's has used his paintings in the advert to generate money without his permission. We are told in the media that he approached them, and Nando's never even wanted to never even wanted to go to court. Instead, they decided to settle out of court. Okay, and how much did they get? How much did they get after settling out of court? We don't know. There is the agreement between themselves. But how did we get to know about the story? We got to know about the story because we were in a workshop and Nando's was there together with this young man, and they are the ones who told us the story. Now, question, why did they tell us the story? I think the reason why they told us the story is because Nando's wanted to protect their reputation. And number two, they wanted to teach other South Africans that you do not use anybody's intellectual property without their permission. And what other lesson can you learn as an SMME? What you can learn as an SMME is, if you want to use somebody's intellectual property, you've got to approach them. There must be an agreement in place. You can either buy it from them, the intellectual property, or you can license them. Otherwise, if you use their intellectual property without their permission, they will drag you to court and they will win the case, because the intellectual property legal system protects their intellectual property, whether it's a patent, whether it's a trademark, whether it's a design, or whether it's copyright. What does copyright protect and what does copyright not protect? These are the rights that I have been speaking about in the previous slide. One, copyright protects musical works. What are musical works? Those are the notes, the beats, or the melodies. Whether those melodies are pop, rock, whether they are soul, whether they are R&B, whether they are amapiano, which has taken the world by storm. It's a musical right that belongs to the composers, and it's protected. Another right that is protected by by copyright is literary works. Literary works means anything that is written, like books, novels, script, manual of instruction. It's another example that I should include here. They are called literary rights and they are protected by copyright. Three, it protects artistic rights. Example are sculptures and paintings. And in our country, I always forget to include it here. In our country, architectural drawings are also protected as artistic works. Then it protects computer programs. Please call me, for example, software applications, published editions, broadcast, that is audio visuals, radio and televisions. It protects programs carrying signals, sound recordings, the music, the disc, even though discs have gone out of circulation because you can now store music on a computer, but they fit the definition of what sound recording is in terms of the legislation. It also protects cinematography in films. Examples are movies, documentaries, television show, music videos. As long as they are audiovisual, they fit the definition of films. And if you can see below, we have what we call performance. And performance is not protected by copyright. Performance is protected by a separate legislation. We call it the Performance Protection Act. That is why we call performance a related or a neighboring right to copyright. Why do we protect IP? It's simple. You protect what you have so that nobody can use it without your permission to make money. If you've got a patent, you have protected it. Nobody can use it without your permission. Trademarks, I have used an example of Bafana Bafana. Patents, I have used an example of Luveve's bread. Copyright and design. IP also enable people to earn recognition. Today, you and I, we know that Please Call Me was invented by the young Moses Makate, according to media reports, and the judgment that was handed down between Vodacom and Mr. Makate. If it was not because of Please Call Me application, we wouldn't have known about the young Mr. Moses Makate. You all know the story, those who have been following it. As an office, we've been following it for many, many years, since 2001, when Please Call Me was born. Okay? And the other reason why IP is protected is to strike the balance between the rights or the interest of those who innovate and the wider public. While the innovators will get recognition, while the innovators or inventors will get money, the public will get to use the innovations that was provided by the innovators. And another thing is to encourage citizens of each and every country to become creative and innovative. That's the reason why we protect intellectual property. These are the rights that I have been talking about as far as copyright is concerned. Here it's music, for example. Top left, you can see a record company. In terms of the law, they own a right called fixation, or they own a right called mechanical rights. In the middle, we see the type of rights, the bundle of rights that I was talking about, owned by different people. There is a performance there. Somebody has wrote the lyrics, and those rights are owned by the people who created those rights. But where do they lose those rights? They lose those rights on the right. This is where these rights exchange heads. On the right, we see what we call the law of contract. Most right holders will go into a contract with the recording companies. It is the decisions that they make here that enables them to keep these rights or to sell the rights to the record company, because the rights by law belong to them. But in practice, they always, most of the time, they forfeit this right, because a record company would put a contract on the table and say, I want to record you on condition that when I record you, I get to be the owner of the lyrics, which is literary works. I get to be the owner of the performance, which is the singing, and then I get to be the owner of the soundtrack, which is the old. Based on the circumstances, we know naturally what happens because of the desperation of these people. They end up agreeing with a record company because of fame, because of money. They end up agreeing and agreeing that the record company should take the rights. But nothing stops you from saying, no, even though you record me, I still want to be the owner of this right, and that should be included in one of the clause in the contract. With films, the same thing happens. Those are the rights in the middle, the performance by the actors, okay, the script, which is literary work, okay, the soundtrack, those rights can either be retained or can either be sold to the film producer, depending on the type of contract on the table. This is what I'm talking about in pictures. This is a performance, okay? It's a stage performance. In terms of the law, it is owned by these performers. It depends on this performance whether they want to keep this performance or they want to sell it to the producers. This is another example of a performance, whether it's in the studio, whether it's in front of the audience. Here it's in the recording studio, where the record company would record somebody. So it is the decision of the performer whom you see whether he or whether she wants to sell this to the owners. Now, here's another thing that makes copyright very, very complicated. Unlike trademarks and patents and design, when it comes to copyright, you do not register copyright. The South African copyright law gives you automatic protection. In other words, if I write lyrics to a song, I get automatic protection. If I produce a melody, I get automatic protection. If I paint a very beautiful painting, I get automatic protection. However, there is one exception. In South Africa, the only type of copyright that we register so far is films, even though films also enjoy automatic protection. Now, people often ask us, why do we have to come to CIPC and register for a film, even though films also enjoy automatic protection? I will tell you in the later slides. But this non-registration process creates a lot of problems, because sometimes when there is an infringement, most of the creators get it difficult to prove ownership of copyright in the court of law because of this non-registration process. However, some members of the Berne Convention, the international agreement that I spoke to you about in the beginning, which is responsible for the protection of copyright, some members like the US, Kenya in Africa, realize that this creates a problem, especially when there is an infringement. It is for these reasons that these countries decided to make this a very seamless process. They are going to come up with a depository system for all copyrighted works, and they did exactly that. And it made life easy, because if you write the song, you approach the copyright office. If you are in Kenya, you deposit the song, they give you a number that is proof of ownership. If you are a painter, you can deposit your paintings. As South Africa, we also want to follow suit, and we also want to put together a depository system. It is for this reason that in 2015, I think, they sent us to Nairobi, to Kenya, to the Copyright Office of Kenya to see how they do it. And in 2019, they sent us to Washington, the Copyright Office of America in Washington, to see how they do it. And they have pledged to help us. So it's on the cards. Okay? Now, this is what I told you in the previous slide. People are saying, why should I register a film? Because a film is also automatically protested. We say, yes, it is automatically protected. You don't have to come to CIPC. But if you register a film with CIPC, you get a registration certificate. And that registration certificate give you prima facie proof of ownership in a court of law if there is an infringement. You don't have the burden of convincing the magistrate or the judge that you are the owner of the film. One other advantage is that when you apply for film protection, there is information that we require from you that would help you in case there is an infringement in the future. We want information like who are the directors, who are the actors who wrote those scripts. That kind of information might come in handy when there is an infringement in future, because it will help clarify the roles. It will help clarify who owns what in that film. This is how you register a film, just like a patent. You go to CIPC and register films. You are an SME somewhere along the journey of your business. You might want to switch into other markets, for example. You might want to go into patents, copyright, trademarks, and designs. You might want to open up an IP law firm and become an SME within the intellectual property space. That is something for you to consider. If you want to be a patent attorney, obviously here you need a technical degree, like a degree in science, physics, chemistry, biochemistry, you name them. And you also need a degree in law, LLB. It's a combination of a technical degree and a legal degree. From there, you become a patent candidate attorney at an IP firm. That's where you'll get experience. That's where you'll sit and write board examination, and you become a qualified patent attorney. If you like to be a copyright lawyer, there is an opportunity for you as an SME, where you will be able to take care of your clients' repertoire, whether in music or any other copy-related work, or you can specialize in trademarks and designers. And another opportunity, save money, open up a recording studio if you operate within the creative space, and you can record young upcoming artists inside South Africa and outside the border of the country. You can be a producer of films and documentaries and music videos. I think I have come to the end of my presentation. Let me stop here for questions. Let me stop here for comments. Thank you very much.
Thank you, Modulefa. That was really a very interesting presentation. I've learned so much from it. Okay, so we're going to the questions, right? I'm going to only address the ones for IP related. Okay. How does the trademark check and registration work?
How does a trademark
check, and I think he means how does a trademark search and registration work? Can you give us a more explanation on it?
Yes. A trademark search is there for one purpose. A trademark search helps you to check if somebody or another company has applied for a trademark that you have in mind. That's the purpose of a trademark. Because if you do a trademark search and you want to apply for a certain trademark for a name, for example, and you find out that another company has already applied for a trademark of that name, don't bother. It's a waste of time and money, because CIPC is going to decline. And the reasons that they are going to advance is that that trademark has already been granted to somebody else or to another company. Then trademark registration means the process of lodging an application for a trademark, for example, a trademark to protect the name of your company, or a trademark to protect the name of your product, or a trademark to protect the name of your slogan, or a logo if your company has a logo. Thank you.
Thank you for that. The next question is from Justine. In the case of a book royalties, what happens if the original author is deceased? Who will the royalties then be paid to?
That's another good question. In terms of our South African copyright law, which I forgot to mention, copyright, it's protected for 50 years after the death of the author. In other words, if I write a book, it's protected for 50 years. If I die today, the same book is protected for another 50 years after my death. After 50 years, it goes into the public domain. It goes into the public domain. Anybody can take my book and can take my book and adapt it into a stage play or into a movie. Now, to answer your question, after my death, the book is protected for another 50 years. Now, who gets the royalties after my death? Obviously, if I am a married person and I am married in community of property, my wife will. If I am not married, obviously the royalties will be collected by my children. However, don't take it for granted. Intellectual property is like any other property. While you're still alive, please do a will and indicate that in case of your death, where do you want the royalties to go? To your children or to your brother if you're not married? So those are the little things that we take for granted. I hope I've answered that question.
Thank you for your answer. How long does it take to get a company name to be trademark registered?
Okay, that's another good question. Intellectual property application process take longer than companies. When you register a company, the process is quick. Shanae knows exactly what I'm talking about. But when it comes to intellectual property, the process is longer. When you apply for a trademark, for example, the process will take you between 12 months and 18 months. And one of the reasons why it takes so long when I ask the trademark registration people is that when you apply for a trademark, one, there is an examination process that takes place. In other words, there are trademark examiners within CIPC. We will examine your trademark, do the search and all that. And then it goes into the patent journal for quite some time, usually 3 to 4 months, to see if there are any objections. And when there are no objections, the process goes on. So to be safe, look at something between 12 and 18 months for the process of registering a trademark.
Okay, this is a question from me. What happens if somebody else registers my trademark within that 18 months period?
Okay, that's another good question. Like I said in the beginning, intellectual property protection works on a first-come, first-served basis. If you, Shanae, apply for a trademark today, obviously, we will give you what we call a trademark application number. If I come tomorrow and apply for a trademark, I am already late, even though your trademark has not been granted.
Okay, so I'm still protected.
You're still protected.
What rights do agents have regarding payments with IP that belongs to the performer?
Can you repeat the question?
What rights do agents have regarding payments with IP that belongs to the performer? So I think this is related to music. So if
yes,
I'm an artist and I want to sing, what rights do my agent have?
Okay. And an agent is the person, if you're a musician, who takes care of your music repertoire. An agent protects you from anybody who might want to use your music without permission. An agent is there to negotiate contracts on your behalf. Obviously, the agent does not have any rights to your music. He only gets what is due to him in terms of the agreement between you, the music owner, and a certain agent. If you, as a music owner, wants to give some rights to your agent, that decision is entirely up to yours. But in terms of the law, an agent does not have any rights to your music, but he has a right to be paid in accordance with the type of agreement that you came into together as the music owner or the performer and the agent.
Okay. Now, this is the second part to the question. What rights does an employer have over your designs and IP that was created by one of their employees?
That's another good question. In terms of intellectual property laws, the employer becomes the owner of the intellectual property if the intellectual property was created by the employee during his employment tenure. I am going to give you an example, and I'm going to give you an example using copyright. You see this presentation in terms of copyright, it's called literary rights. And I am Mujale Fakoza, I'm an employee of CIPC. And one of my responsibility is to put together this presentation in the form of slides. Now the question is, am I the owner of this PowerPoint presentation, or is it CIP that owns them? In terms of the copyright law, CIPC owns this presentation because they pay me each and every month to do this presentation. However, sometimes there is a difference. If you look at the Please Call Me story or saga between Moses Makate and Vodacom, the law says, there is a clause that says, the ownership might belong to the employee if the contract so states. So we can only deduce when we look at the case of Please Call Me between Moses Makate and Vodacom that Mr. Makate was not employed in the product development unit of Vodacom, but he was an IT specialist. So we can only deduce that the reason why he won the case, it's because he was not in the product development division of Vodacom, but in the IT division. I hope I've answered the question.
No, that is good. That is really good. Tell me, if I have an idea, can I register it as a patent?
That's another good question, and I get it all the time. When you have an idea, it is not protectable because the idea is only in your head, and you cannot protect what's in your head. When you have an idea, you've got to work on that idea until it becomes IP. IP can be a product. Otherwise, if it's not yet a product and it's only an idea in your mind, that is not protectable.
Okay. Can you only register the brand behind the idea?
Can you register a brand behind the idea?
Yes.
Yes, you can register a brand because in terms of the definition of the Trademarks Act, a brand can be a product. And if it's a product, then it has a name. Yes, you are more than welcome to register and protect the name of the brand.
What about the recipe? Is that a patent?
The recipe, if it's a brand, if you have a brand, if that brand is that brand, for example, has a recipe, that recipe will be protected by a patent. And if you give that brand a name, the name of the brand will be protected by a trademark.
Mandy Davis, I hope that has answered all your questions. Our next question is from Linda. If you are busy developing the recipe of a product, do you only register the patent once the recipe has been formulated, or do you register the patent and then refine it based on the recipe?
That's another good question. You can only register the recipe as a patent once the recipe is completed. However, while you have lodged an application and you want to add something into the recipe, In other words, redevelop it, the law allows you to do that. In other words, while you have lodged an application and you want to make some additions to that recipe, the law allows it.
Okay. And you said it takes about 18 months to have a trademark approved.
Yes.
That's correct.
Yes, at
Okay.
most.
Okay. So, Mr. Goodman, if you can just wait a few more months and then we can let you know about whether your trademark has been approved. Okay. How and where do you do a trademark search?
Yes, there is an option for a trademark search on our CIPC website. You can go there, punch in the word, whether that word is the name of a brand, whether that word is the name of a company, it will give you some preliminary results whether that kind of trademark has been registered by someone else.
Okay, our next question is from Regina. Is it the IP lawyer or the IP manager that helps with the evaluation of an IP and can assist with the best strategy to then instruct the IP lawyer what is best?
Well, I think if you are a company and you have an IP manager and you want to evaluate the value of your IP, if that IP manager is qualified to do what we call an IP valuation and give you an exact value of your IP, then I don't think you need to go to a lawyer. But if you want second opinion, you have an IP manager for your company, and he has done a valuation of your IP, and you still need a second opinion, you can request your manager IP manager to consult an IP lawyer, because I believe, I'm not undermining IP managers depending on their qualifications and their experience, but I believe an IP lawyer is the one who is in a position to give you a more accurate valuation of your IP, given the expertise that they possess.
Okay, thank you for that. Are copyrights rights transferable? For example, if you have a painting or a photograph and it has been sold, do you transfer the ownership onto the person that has bought it?
All IP are transferable. If I own a trademark for a name of my company and I want to sell it to you, Shani, and I sell it to you, it means I have transferred my trademark rights to you. I'm not the owner anymore. The same applies to designs. The same applies to patents. The same applies to copyright. If I am a painter and I paint pictures, I am the copyright owner of the painting. If I want to sell my painting to Shanae and I sell it, it means Shanae is now the owner of the copyright. So to answer you, yes, IP rights are transferable.
Okay, for example, with regard to a painting. Now, I'm the artist, but I sold it to Pearl.
Yes.
Does she have the rights to it, but yet I am the artist?
Yes, she has the right because she has bought it from you. However, it has been realized that it's a common practice worldwide for lovers of paintings who go to international fairs, buy paintings for cheap, and then resell them for 20, 30 million. And according to the copyright regime, that is not very fair. It is because of this that in our copyright amendment bill, which is now in Parliament, which now the constitutional court has ruled it constitutional, except on the issue of fair use. There is a provision that has been included there that says there must be something that an original artist get from the resale of her original or his original painting. In other words, that law says if Shanae has painted a portrait or a picture and she sells it to Mujalefa, and Mujalefa go and sell it in Europe for 2 million, then there must be a certain percentage that Shanae should get from the resale of that painting. But I've seen that clause in the amendment, but I'm asking myself, how is it practically going to work? Because if Shani has sold it to me for 10,000, if I sell it in Europe for 3 million, will I let Shani know that I've resold the painting for 3 million? So personally, when I look at that, I can see the reason why they're trying to do that. They're trying to ensure that the original painter also gets compensation after resale. They call it resale rights. What I find it difficult to see is the practical application of this clause that they want to include. We'll see how it will work, Shani.
Okay. Tell me now, we spoke about painting and music. Now, this is regarding music. What about AI compositions in music? Who gets the right?
That's a good question. I was actually having this topic this morning with my manager, who's a technical expert about that. AI is a tool. It's not a human being. And in terms of intellectual property legislations, intellectual property can be owned by human beings. Therefore, if I use AI as a tool to create music, AI cannot own the music because AI is a tool. I am the one who used AI as a tool to create the music. In terms of the copyright law, I still own the music. So we have not amended our copyright law as far as AI is concerned, because we are not yet sure how AI is going to impact on our copyright law, whether it's going to infringe it or not. So at the moment, we are still reactionary. We are still looking at what AI will bring as far as our copyright law is protected, and we will amend accordingly. But so far, AI is a tool, not a human being, and AI cannot own any type of intellectual property. But the person who used AI remains the owner of the intellectual property.
Okay. Now, this question is all copyright forms. Are we not doing the dispository form for films only currently?
Yes, currently we have a depository system for films, but we have realized that it's not fair. We also want to put together a depository system that can allow all types of copyright to be deposited so that the owners can get a certificate that proves there is ownership. That is why I said we went to Kenya, because Kenya is the only country that's doing it at the moment, so that they can show us how they do it. And we also went to Washington to their copyright office so that we can also do it as South Africa. So once that depository system is in place, it will allow for the deposit of all type of copyrighted works. When will it be in place? I am not quite sure. It depends on how far we move as CIPC.
Okay. Is animation also classified as a film?
Yes, animation is classified as a film, because a film is classified as anything that is audiovisual, anything that you can hear and anything that you can see. So animation definitely falls into the category of a film. So you can apply to protect animation, provided they are audiovisual in nature. In other words, you have shot that animation.
Okay. There's a question that says, can a company trademark, for example, a roadmap that outlines how to set up and maintain a specific value chain? So
Well,
basically, okay, you got it.
yeah, in terms of trademark, you cannot trademark a roadmap, but you can trademark the name of that roadmap.
Okay. Please clarify under our law and with CIPC which one is identified as designs and which recognized as patents.
Oh,
Authentic designs and functional designs.
okay, I can only talk about our South African IP laws. In our country, as far as designs are concerned, we protect designs for their looks. We call that aesthetic designs. We protect designs for their function. We call that functional design. Now, if your design has both the look that you want to protect and the function that it protects, you can apply for both. I will give you an example, and I'm going to use BMW 330 model because I know about it. If you look at the BMW 330 model, it's very aerodynamic in shape, especially the bonnet. Now, when we find out, one, there are two reasons it's designed in that aerodynamic shape. One is to make it look beautiful. That's the look, that's the aesthetic design. Number two, the aerodynamic shape of the body, especially the bonnet, is there to reduce fuel consumption. So there is a function to it. So wherever they go, when they apply for protection, they apply for protection for both the aesthetic and the functional. So I can only speak about South African laws. When it comes to patent, there are requirements in terms of our patent law for us to grant the patent to any applicant. And those requirements are novelty, disclosure, and commercial viability. I'm not sure about other jurisdictions. I'm at the moment sure about our jurisdiction as South Africa.
Okay, thank you. Here's a bit of a long question. For those of us developing a platform with global aspirations, a critical next step after filing a provisional patent in South Africa is utilizing the Patent Cooperative Treaty to manage international filings. To clarify the timing of our strategy, does the CIPC emphasizes that the submission of the formal PCT international application must be completed strictly within the 12-month provisional period to claim the original South African proprietary date internationally, and what happens if the exact deadline is missed?
Okay. Now, in terms of the patent law, when you want to file for a patent, you can start by applying for a provisional patent. And a provisional patent gives you a period of 12 months where you can make amendments, where you can, for example, develop a prototype if you like. But if you want to file a complete patent, not only in South Africa, but you want to file a complete patent globally, yes, the Patent Corporation Treaty system is the ideal application system that you can follow. And this is the reason why I say it's the ideal one to follow. Because when you launch PCT, which is an international application system for patents. Then there is an international patent search that is done for you, and the international research report will come back and say, we think you can apply for a patent, for example, in Indonesia, but you cannot apply for a patent in the US because such a patent has been filed by company X. It will help you to save yourself time and money because you will have an idea of where globally you can actually apply. But what it effectively means is that the very same date when you have filed that international application system, it will give you protection against those who wants to file a similar patent internationally in countries where their application has not been made.
Thank you for that. Okay. When I do a trademark application, they, I get a message that says unique reference cannot be empty. Do I need to insert a unique number in that column?
I'm not quite sure about that. The people
Okay.
who will be in a position to do that are those in the registration. I am going to note it and I'll have a discussion with them and I can be able to provide an answer.
Okay. Thank you for that. What is the nice classes when doing a free search? There's something called a nice class. What are they?
Okay, a nice classification is similar to PCT. It's an international application system for trademarks. Okay, now when it comes to the NIST classification system, I can only talk about the CIPC classification system, but I can deduce that they use the same classification as CIPC on behalf of South Africa. We've got 45 classes, and the first 15 classes deals with goods and services, and the other classes deals with the rest. So I'm not quite sure about your question, where your question, which class would it fit in? But if those are goods, then it will fall within class number 1 up to 15. And then if those are services, it will fall from 15 up to about 35. So I'm not quite sure if the NIST classification uses the same NIST classification as CIPC, but I assume they use the same all over the world, even the NIST classifications.
Okay. Paying for something is not equal to transferring of copyright. There is a certain copyright transfer deed that must be entered into. This deed includes transfer duties, taxes, and or royalties, if any are applicable. Is that correct?
Well, of course, if I'm the copyright owner and I want to sell my copyright to somebody who is overseas, we have to come to a written agreement. And obviously that the written agreement should include things like those. They should indicate whether it's an outright sale of my copyright, say if it's a painting, and if it's going to incur import or export duties, we should take that into account in our agreement. In other words, we should agree between myself as the seller of copyright and somebody overseas who's the buyer of my copyright, whether in the price I should include import duties or export duties. That is determined by the seller and the buyer of copyright.
Thank you. If I did a logo with AI, can I trademark it?
Definitely, yes. Like I said, AI is here. It has invaded industry. It has invaded all spaces of life. Countries at the moment, especially in Africa, are still grappling with how to transform or to adapt their intellectual property legislations to accommodate this baby called AI. But so far in our country, we have not amended our legislations. Experts are dealing with it to amend it, to adapt it, and incorporate AI. But AI is a tool. And if you use a tool to come up with a logo and you apply for protection in terms of South African trademark law, they will grant because you'll be the trademark owner.
Okay, that brings us to the end of our questions, but there's a last comment here. NIS class simply means the industry of trade under which your trademark falls under and operates in. Sorry. NIS class is universal. This is applicable even in local transfer of copyrights.
Thank you for the comment. And that's exactly what I said. I said, I think the classification system, which in South Africa is from class 1 to 45, I think it's universal and it's in line with the NIS classification. Thank you for that comment.
Okay, there's just one last one that just came in now quickly. How do we extend our provisional patent deadline? How much does it cost and what extra time does it grant?
Okay, our provisional patent is very cheap. It's only 60 rands. But in terms of the patent law, after 12 months, you are required to file a complete patent, which means you've got 12 months once you filed your provisional patent. After 12 months, you've got to apply for a patent, for a complete patent. So it means you've got only 12 months. Whether you can extend it beyond 12 months, I am not quite sure. I'll have to find out that from you and come back to you.
Thank you for that. Okay.
I will find out if there is an extension.
Thank you, Modulefa. We really appreciate that of you. I now hand you over to Pearl. Thank you.
Thank you very much. Thank you, Shanae.
Pearl, you can take over.
Thank you to our presenters for their informative presentations, and thank you to everyone who joined us today. We hope you found the session valuable and gained useful insights into company registration and intellectual property. Before you leave, please take a moment to complete the feedback survey link that was shared in the chat. Your feedback helps us improve our future webinars. A recording of the webinar and the presentation slides will be emailed to all registered participants after the session. On behalf of CIPC, thank you for your participation. Have a great day, everyone. Goodbye.